Stanford. I'm coming to you from the sunny confines of our Florida office where Oliver is next door. So if you hear more than one siren today, it's just the echo that's coming through from both of our screens. But it's been an exciting week at the court. We've had opinions, we've had oral arguments, we've even had some grants today, and we're going to talk about all that today. In that order, we'll start with opinions, and then we'll move on to the oral arguments, and end with some grants. I think most of the time today will be devoted to the case that most everyone's talking about, and that's the Little v. Hecox and West Virginia versus BPJ, which dealt with whether trans females can play in boys or men's sports. But before we get there, we had three exciting opinions. Actually, before we get to the opinions, I must announce I retain my first place belt in the Fantasy SCOTUS, cruising by all of you guys, and I would almost have a perfect score, but for in the Montana case that was decided this week, I put reverse, because I'm like, there's no way they're going to affirm that Montana opinion. But of course, rookie mistake, it is the judgment that was affirmed, even though they rejected that opinion, and so I got 0 points for that. But I'm still smoking both of you. And
that's because we're not really participating.
Well, whose fault is that? I'm gonna keep bringing it up until you guys start getting some points. Anyway, let's move on to the opinions, and we have three opinions. Anastasia, why don't you lead us off with the Boss decision? Now, our loyal listeners will remember this case deals with whether a sitting congressman has standing to challenge election rules. What did the court say?
Yeah, so I mean, I just want to mention the facts because I think it's novel and interesting, which is that this candidate for office in Illinois had challenged Illinois' policy of allowing ballots to be counted within 2 weeks of being received, so long as they are mailed by election day. And the candidate says this violates the federal law that sets election day on election day because it's allowing ballots to be counted even if they're received after election day. And of course, he got kicked out on standing. The court didn't even get to the merits. He said he was injured because, one, he's forced to spend extra money monitoring the elections beyond election day. And even if those votes, there's a separate injury he alleged, which is even if those votes don't make a difference between him winning or losing the election, in politics, margins are still really, really important. I mean, especially libertarians knows this, we're just trying to shift the Overton window sometime, not trying to win or lose. And
are you an LP member, Anastasia? Are you announcing your LP membership?
No, I'm not. I meant even philosophical libertarians are trying to shift the Overton window, right? I'm loyal to no one, except for me, myself.
Well, I vote for you for president every time.
Right, so the margins matter to me, Joshua. And I believe you've been writing me in since before I was too young to be eligible. But anyway.
Aren't you still too young, Anastasia?
Right. So in any event, he alleges these injuries, and the government and the lower courts agreed that he's not injured by having to pay extra money after election day because any money he spends is a self-inflicted wound. He didn't have to spend that money. He chose to, which is kind of baloney. And then any injury he has because the margins are changing are speculative because you don't know what's going to happen. We don't know which way those votes are going to go. And so the Chief Justice wrote this opinion joined by a majority of the court, obviously. I'll get into the breakdown a little bit later. But anyway, he reversed and said, of course, this candidate has standing to challenge election rules. He analogized to a 100-meter dash where it's like, hey, if you're in a 100-meter dash and then they extend it to 105 meters, you're injured, even if you're not necessarily going to win or lose based on those 5 meters because it's not fair anymore. You're not playing by the rules that you agreed to play by, which I thought was really interesting. That's a broad decision. It's like, hey, candidates are affected by all rules because they're entitled to a fair election. I was like, oh, okay, Supreme Court, just a little unusual. And that's why you get this divide between him and Justice Barrett, who wrote a concurrence joined by Kagan, where and the majority and Justice Barrett are kind of going back and forth on this. I thought it was kind of spicy, especially of the chief. But Justice Barrett says, no, that's like made up and too esoteric. The injury is the financial injury. Elections are important, she says, but so are a lot of things. That's not enough to give you standing. And then the chief kind of slaps back at that in his opinion and says, well, that would have the weird result of meaning if you spend $1, you now have standing, but if you rely on volunteers, you have no standing. That can't be true. The candidates they're all injured by this unfair process. And then one last thing, figuring into all of this was, I think, the idea that the entire court was really uncomfortable with being thrown into, if the candidate can't challenge it now and can only challenge it on the eve of the election, that puts the courts in the worst possible place to be, they're having to make guesses about who's winning. They're having to jump in at a very heated political time. And so the chief was like, you should just be able to challenge it now. In dissent, Justices Jackson and joined by Justice Sotomayor say, no, this is going to open the floodgates. It's going to open the floodgates to litigation, and it's going to invite the very thing that you don't want, which is more cases challenging election rules. And I, for one, have just become totally, like, my eyes glaze over when I read the word floodgates now. Like, hyperbole doesn't even affect me because the dissents have been kind of hyperbolic in recent years. And so, but that was the dissent.
Yeah, I couldn't agree more, and the floodgates rationale is one that just bothers me to the hills. I will say what really I appreciated is Roberts' response to that. But what I'll say, his response is something to the effect of, nobody's going to start suing over like the wrong font size or the different color of ballots. It's going to be a huge waste of resources, and nobody's going to spend their money litigating frivolous lawsuits. I'm like, yeah, that's the point. Whenever people raise the open the floodgates, that's always the response, Chief. It's not just like election. So I sort of agree with Barrett that why are we creating these election special rules? At the same time, open the floodgates. Nobody's going to file frivolous lawsuits or ridiculous cases. The courts can address those with 12b6 motions. All this standing nonsense needs to go by the wayside. So I was glad to see like there's actually the chief responding to the floodgates argument in his majority opinion, which I'm sure we will be citing in the future.
Yeah, now we just need him to remember that in future standing cases outside of the election context. But I had the same reaction. I was like, yes, release the Kraken, like open those floodgates. And I wrote that in this week's SCOTUS Scoop. That's going to be released later. So we're on the same page.
Are you old enough to know what Release the Kraken is from? No, you're not.
What is it from?
It's Clash of the Titans, the original.
The original? There's more than one?
I was going to say, it might be
there was like a remake.
A little older than that, but
what's that?
nothing. I mean,
Clash of the Titans is from like the early 80s, I think. But I think they've actually like made like a sequel and like another one, like a bunch of them in like the modern era. But I haven't seen any of those. The original is the way to go. It's got the great Perseus slaying Medusa scene with the shield. Oliver, you with me on this?
nope, never seen
No,
it.
man.
Born yet.
One other question on this. So it's going back down to be litigated. What do you think of the actual merits of this idea that you can't count ballots after Election Day?
It seems odd. I mean, we're counting ballots past Election Day all the time, right? Like that's just what that would be crazy to say they have to be counted. And they are cast. They're cast on Election Day because they're mailed in. So it's certainly novel.
Rule, right?
Yeah.
What's that?
It's the mailbox rule, basically.
Yeah, I don't know. I mean, I don't think it's novel. It's interesting.
Yeah. All right. Case v. Montana, the case that I got completely wrong in Fantasy SCOTUS, although I should have gotten it all right. This was the case that dealt with whether police officers, there was the guy who was in his home, he had his girlfriend called the cops, said he's going to kill himself. Cops show up, knock on the door, he doesn't answer. They look through the window. I think they see some things that are indicative.
An empty holster and
Empty holster, right.
maybe a suicide note.
Right. And so they enter. He didn't kill himself, but they find other illegal activity, I think, and then arrest him. And he tries to get the stuff
No, he
suppressed.
came out and they shot him,
Oh, even better. Okay.
and he
But
sued.
but he lived, right? He.
Yes, and the defense was that he shouldn't have been in the, or that they shouldn't have come in. He was sued and said they shouldn't have come in.
Right. Okay. Well, why don't you take it from there, Oliver?
Well, that's all I know. And so the court said though that it was reasonable. There's an exception to the Fourth Amendment for emergency situations when someone needs health services or something like that. And part of the reason for the dispute here is that the girlfriend apparently told the cops he's threatening to kill himself. The cops knew who he was. They'd been to his house before, so there was some thought that he was trying to do suicide by cop and initiate the confrontation, basically. And the court said there was enough. There's a reasonable, objectively reasonable reason to go in.
Yeah, and if I remember from the oral argument, his reasoning that it wasn't objectively reasonable was like, I do this all the time, and they should have known that I was faking,
Yeah,
something like that.
right.
Yeah, so it's a pretty straightforward opinion. The court just says, I forget what the case was that they reaffirmed for officers have to have an objectively reasonable basis, but they thought the Montana Supreme Court sort of strayed from that standard and therefore just sort of like reaffirmed it. I thought the interesting things about this case were the two concurrences, because it was a unanimous opinion. Sotomayor concurs to say something like, okay, in this case it was objectively reasonable, but other people with mental health, cops may be making it worse by entering the home, so don't take this for much precedent. That was, and then even more interesting than that was Gorsuch's concurrence, I thought, which he's like, okay, objectively reasonable, I kind of agree with the result here, but where are you getting that from? Why is it, what is it based on? You can't just throw these standards out of the air and say that that's what the Fourth Amendment requires. So he actually tries to ground it in common law and the text of the Fourth Amendment, and that actually is what he ends up doing in the next case too, that we're going to talk about, the next opinion. But it's interesting that Gorsuch is writing those extra opinions in order to ground the opinions in sort of a historical text.
Yeah, we could use a lot more common law analysis.
Yeah. Which brings us to Barrett versus United States. This was another mostly unanimous opinion dealing with, it was the case that dealt with, there was a statute that you could get convicted on two different things. Oliver, it seems like you're ready to talk about it.
I can summarize the facts, and then again, that's all I know. There's a statute that precludes carrying using a firearm while engaging in a crime of violence or drug trafficking, and then there's another section of the statute that enhances the penalty when somebody dies. And so the question before the court was whether a defendant could be convicted of both provisions for one act. And the court eventually said no, these were two separate statutes, and there's not enough in the text to say that they can be applied twice like this.
So the two interesting things I thought of this opinion were, again, the breakdown. It was unanimous for most of the opinion because Justice Jackson's writing the opinion. She writes a opinion that basically holds that the statute, it's a statutory interpretation case. And she says, well, we start with the text says A, B, and C, and therefore it comes out this way. Then we look to the structure of the law, and then let's also look at legislative history. So all of the justices agreed to the first two, and then on the other part that says, and Justice Jackson delivers an opinion with respect to Part 3. So she doesn't have a majority on sort of whether the legislative history can be used, which was very interesting. But also interesting is, again, Justice Gorsuch writes a concurrence in this case saying, yeah, right result, but there's a double jeopardy issue that we need to be thinking about with these cases. So when, it's very common for prosecutors to charge, say, like murder and manslaughter and other lesser included offenses. But if you get a conviction on both of them, you can't get a sentencing for both of them. You only get, otherwise it would be a double jeopardy problem. He said that's the same thing that's happening here. If there are statutes that allow for convicting for the same underlying offense 2 different times, that would be a double jeopardy problem. So it's something that we need to be mindful of going forward.
I don't know, but I don't know. I didn't read the opinion, and I don't know much about this area, so I should be quiet. But I'm just curious. I thought it's not double jeopardy if Congress intends to make it 2 separate crimes, even if it's the same underlying facts and the same elements. It's a congressional decision, not a judicial decision. So I thought, like, what's the double jeopardy problem if Congress had decided to make it?
I didn't read it closely, and I think you may be right doctrinally about that. I think what Justice Gorsuch is saying is that historically, a lot of these statutes may raise double jeopardy problems, and we ought to be mindful of that going forward. And there are going to be cases that arise. I think he's sort of laying the groundwork for, a more robust double jeopardy clause, maybe striking down some of those things that are otherwise permitted.
Because there are a lot of exceptions, right? Like the separate sovereign rule, so you can be double jeopardy. You can be charged with the same thing in 2 states, even if it's the same crime, same elements. And then federally and state, you can be charged. People don't realize that, like, there's a lot of holes in that, right?
Yep. Okay. Well, those are our 3 opinions, bringing up to 4 for the year. Still no tariffs. Oliver, when are we going to get tariffs?
I don't know. There've been in the last week or so, there've been some predictions that was going to come out the end of last week and then middle of this week. And I saw somebody speculate that the longer it takes, the more likely Trump's going to win. But who the hell knows? Nobody knows.
Let's talk about the oral arguments this week. Let's just start with the one that got most of the attention. This was 2 consolidated cases, one out of Idaho and one out of West Virginia, dealing with whether trans girls can participate in girls' sports. And Anastasia, you previewed this case for us. What did you think of the arguments?
Yeah, I thought it was interesting how much of the argument wasn't actually about the result in this case. It seems to me this case is a foregone conclusion. The court's going to uphold these laws which ban trans athletes from participating in women's sports. And the argument really devolved into actually a broader conversation about as-applied challenges and plaintiffs trying to sort of pick off slices of the law as applies to subclasses or subgroups rather than attacking the law on its face. And that's because one of the plaintiffs here had tried to mitigate their physical advantage over women by suppressing testosterone, I think it said just for 1 year. And you would think that's kind of where I thought the court would go, like, hey, is that really mitigating your advantage? Like, you still have an advantage and you can be banned. But instead, the court kind of sidestepped all of that and was like, we don't think that people should be able to bring this as applied challenge, at least in the intermediate scrutiny context. And to me, that was actually, Joshua, I don't know, we've talked about it before, maybe we have slightly differing things, but I'm just wary anytime I see the court kind of closing off an opportunity to challenge a statute under the Constitution. It scares me. And so it really seemed like a lot of the justices were buying this, that you should be able to bring as applied challenges, and I thought that was a little frightening.
Yeah, I mean, I do think that is the story of the argument, like this as applied versus facial distinction. And it's interesting that, as people who have been litigating equal protection cases for a long time, that this issue has never really come up. Now, I deal a lot with, racial challenges, and those I think aren't as applied because you are sort of striking down the entire classification. I think that's probably mostly true with sex as well. But where it really is more difficult to conceptualize is why you can't have an equal protection challenge in a rational or an as-applied equal protection case in a rational basis lawsuit, which we have certainly litigated a number of those. Now, I will say, having not thought about it much until Wednesday and listening to the arguments, I find some intellectual force behind it. I share your concern about doors being closed, especially, there aren't that many doors open to challenge economic regulations that are violating rights of individuals. So to close the equal protection clause would not be a good thing. But then the other bird on my shoulder is thinking, well, maybe we can still bring those cases. They were always sort of properly understood as facial claims. And so I've been wrestling with the idea, some in my head. It's an interesting academic question, but it will obviously have real world practical consequences to our litigation in particular going forward.
But
Yeah,
will
just
it?
oh, go ahead.
Will it? Because I mean, I don't know. I'm not trying to. And maybe this is a stupid question, but I mean, it seems like this is a very unique circumstance that the person claiming equal protection is arguing in effect, well, never mind, now it's equal, sort of. And so or at least is backing out of the, anyway. So when else would this come up? I mean, do any of our cases have been able to make this argument that there's a subclass and therefore there should be an as applied analysis?
I went around and around with ChatGPT on this question a little bit after me and Anastasia were discussing it, and
That wasn't good enough. He had to go to ChatGPT.
well, I don't know that ChatGPT did better. I kept on yelling at it, like that's not what I mean. I think this is what the best that it came up with, and I don't think it's right. So I'll give it, and maybe Anastasia has a better answer. But take for example a law that requires veterinary licensing. And now you have somebody that wants to give like dog massages, whatever that's like. I forget what that's called, but some people, that's a profession that some people do. And they say, well, we're not challenging the whole veterinary scheme. We're just challenging that it applies to dog massage people. And I think at first blush, yeah, that does kind of sound like an as applied challenge. But I think you could also say, no, we're like categorically, facially challenging how this applies to dog groomers, whatever the hell you want to call that profession. In other words, you're not striking it down for that person. You're saying that the rationale applies to that whole class of people, and so you could still characterize it as a facial challenge. That's sort of what I'm toying with. Is that maybe what we think are as applied are really actually facial challenges.
But it's weird, right?
Yeah,
It's so hard. Yeah, it's so hard to win facial challenges. And then there's the tension between the fact that in a facial challenge, you have to show that the vast amount of applications are unconstitutional if you want to win. But then you've got, like, undoubtedly, they're really hard to win. Like, you can never. So but I think all of this is because the court and the advocates were getting too hung up on scrutiny in terms of overbreath or underbreath rather than means and fit in terms of like how rational is it. Like, sure, I think that if something is overbroad or underbroad, that is an indication of poor means and fit, but that's not the only way that means and fit works. And it's because the court kind of got dragged down the whole rabbit hole of overbroad or underbroad that all those problems started to arise. But if we just thought about the fact that who cares if it's underbroad or under-inclusive or overbroad, like, it doesn't make any damn sense, you know?
Yeah, there's a couple of competing things going on here too. I think like I mean, it was clear that, Justice Kagan, who I think we all hold very highly, was like, I'm surprised there's very sparse authority on this. She seemed very engaged with the academic question. And I was going to say, so on the one hand, what you're challenging in an equal protection case is the classification. The government is making a classification, and the question is whether the reason for the classification is justified by the means that are undertaken. So in that respect, it does seem weird to say, well, my personal circumstance means that there's an equal protection violation, because it's the classification that has to have the means and fit, not its application to any particular individual, I think, conceptually. On the other hand, we always talk about how the right to equal protection goes to the individual, and it's the individual's right to equal protection. So to totally ignore how these laws impact individuals also seems to be a little bit at odds with the jurisprudence. So we'll be thinking about it, but let's move on to like a little bit more of the case. On sort of the merits, I think you said, Anastasia, you think it's a foregone conclusion. How do you think the court actually adopts this tact, or does it say something to the effect of intermediate scrutiny applies and these satisfy intermediate scrutiny? You're muted.
I was saying, actually, this reminds me of a couple of interesting things that came out at oral argument. So I knew that this is just apropos. I'm going to sidestep the question for 1 second, which is I knew one of the plaintiffs was trying to get rid of the cases. She wanted it dismissed. And I thought it was really interesting in this case how much the government was trying to force this plaintiff to stay in the lawsuit. And it looks like the court just might force the plaintiff to stay in the lawsuit. And that's just so unusual for a court that will kick out cases whenever it can. Was like, and I get it. I think it's because everyone is a little circumspect that this plaintiff wants out after cert's been granted. It's like, hey, you can't, come on. It seems unfair. But on the other hand, it's just so unusual for the court to force a plaintiff to maintain a lawsuit. And as Justice Sotomayor said, this person's name is going to go down possibly in constitutional law books for all time. They'll be the subject of histories, and that's you're going to force this person to do it. So I don't know. I mean, really, maybe they'll dismiss that part of the case, but it kind of seemed like they want to keep the case in.
On that point, the difference in the two cases, as I understand it, is the Idaho case, the one that they want to moot, raises an equal protection claim, whereas West Virginia's only Title IX. Is that right? Maybe that's not right, but it's all. What I know is right is that the Ninth Circuit gave a definition of sex that I think the Idaho guy was worried is going to bind them. But if it's Munsingware, I don't see how it would bind.
Munsingware, yeah. Yes, I think the West Virginia case was decided under Title IX, but I think the plaintiffs brought equal protection Title IX, so it's not like it's forfeited. I mean, sure, it's probably better to have both vehicles, but when the plaintiff wants out, it's just very odd. It's odd.
Yeah. Okay. That makes so. The Fourth Circuit decided in the plaintiff's favor on Title IX grounds.
Right. Mm-hmm.
Okay.
Okay. Here's another interesting. Oh.
No, go ahead.
Okay, another interesting thing that kind of came out was, you think back to last term on the case challenging bans on gender affirming care for minors. And the plaintiffs in that case really, really wanted the law to qualify as sex-based discrimination, right? Because that got them into intermediate scrutiny. And here, I thought this was really interesting. It's the government arguing for that this is sex-based, not trans-based discrimination. And it's the plaintiffs who are actually, I mean, all things being equal, discrimination against trans people is probably going to get rational basis scrutiny, the lowest level of scrutiny. And yet they're really advocating for that, which is just really interesting. And I think that's because some of these difficult questions from that side about, well, what is sex? How can you claim it's sex-based discrimination if you don't adhere to a working definition or that type of thing. But it's just interesting to see sort of the strategy of each side swapping in those two cases.
Mm-hmm. Yep.
Okay, and then my last, that didn't elicit much. I'll try one more time in terms of.
Well, Oliver wants to say something.
I was going to say something, but you were.
Okay, good. Go.
No, isn't there? Couldn't the trans classification be a suspect classification for certain purposes? For example, here, in other words, the argument here was this is all about sex, not about identity or gender. And the discrimination here, again, is not based on any status as a trans person. But in other cases, if it's, for example, employment, and the discrimination would be on trans status, could that be intermediate scrutiny? Whereas in this case involving sports, it would not be.
I mean, under the Civil Rights Act.
Whatever, either under, just in terms of you get intermediate or rational basis scrutiny. It could depend on what the aim of the Again, because here, the
Oh, no.
argument, again, the argument here is that the classification is based on sex and has nothing to do with, it would apply if a cisgender male applied for a girls' team as much as a trans girls tryout. So it has nothing to do with the trans status, it's the sex status, whereas again, for employment, it could be, there could be a law that says you can't discriminate on the basis of sex and you can't discriminate on the basis of trans. And in both cases, and so in the latter case, you could have intermediate scrutiny, and in the former, you just have intermediate just for the sex classification.
Yes, but isn't it, it's just weird that the plaintiffs wouldn't try to make it out to be sex discrimination in both to try to get that heightened level of scrutiny. And I think one reason might be to stave off the argument that if you make an exception for trans people who have mitigated their advantage by suppressing testosterone, you have to let in any man who doesn't have a physical advantage over a woman. Maybe a man who was born shorter with less lung capacity or whatever, you know, less capacity, like less muscle, less strength. And so maybe that was a litigation strategy to kind of like stave that off by saying, no, it should only be, this only matters when it's discrimination against trans people, and we're going to limit the challenge to that. So maybe that was one of the strategies. But relatedly, I did find a lot of those questions very interesting, that the justices were probing the limits of each side. So when the plaintiff comes in and says, I mitigated my advantage, then the justices were like, well, do we have to let all men in now if they don't have that advantage? And then on the other side of it, you know, the state says, hey, where there's sex-based differences, we have a line and we can have a line. And then the justices were asking, well, do you have to have a line then? Does that mean that the states that allow the sexes to compete are violating equal protection or violating the civil rights laws? And what else could states do? You know, this chess, Joshua, chess reference for our chess fan,
Yeah.
our excellent chess grandmaster at PLF. But, you know, I guess I didn't know this, that women are apparently not as good at chess. And so the justices were asking, well, does that mean that schools can now set up women's and men's segregated chess teams? Must they do that when there are sex-based differences? And that was kind of interesting too.
Yeah, really interesting.
Here's just going back to my, if I may, the Roberts, in one of the cases, he said that in Bostock, I understand, he understood Bostock to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification.
Right. I think he's right about that.
Yeah, I do too.
Yeah.
Yes.
On the chess point, I wasn't, you know, maybe I was too excited to hear them mention chess at the Supreme Court that I sort of lost the point of it. So is the point was, if there are genetic differences between the sexes, that there may be an obligation of the state to create separate sports? Is that what you're saying?
I think the first question is, can a school do that? So, you know, take something that maybe is more obviously objectionable. So women now outnumber men in college. Does that mean that schools can set up remedial programs or extra tutoring programs for boys only and exclude women? So that's like the first question, like, hey, you say sex differences matter. Well, how much, you know? And then if they can, there's then the second question of, must they? Are you suggesting that under the civil rights laws or the equal protection clause, they have to do that in order to, you know, provide true equality?
Yeah, and the original question when they started, I thought one of the original questions when they started going into this is math, because forever men do slightly better on math, and then said, all right, what about? And then I think it was Kagan who said, all right, what about chess? And then at some point in the argument, they said we have all these studies, and I think it was Mupan at that point who said, well, I don't think there were any studies or people relying on things that say men are better at math than women, and both Barrett and Gorsuch said, no, they did purport to have studies on that. So it wasn't interesting because because Sotomayor, for example, was just all over the evidence or the supposed evidence. She kept saying that we're here on a preliminary record and we should see what the science is going to say, and But I think, as the last example on math shows, I think it cuts both ways.
Yeah.
Yeah.
Anything else on these two cases?
I just, Joshua, I said to you this afternoon, it was noticeably less ideological and partisan than Bostock. It just,
I mean, Scrimeti.
I'm sorry, Scrimeti. It just seemed like everybody, for whatever reason, just it's kind of the common sense here, I think, controls where it didn't in Scrimeti, or at least it didn't as much. And it just seems like everyone knows what the right answer is, and just trying to figure out how to do this as on a stage set. You know, what's next? How do they write this in a way that doesn't require discrimination or be overbroad with the holding here or whatever. But it seems like maybe Jackson will be on the other side, but it seems like at least Sotomayor, I think, is going to rule for the government on Title IX.
Yeah.
I think. So that's got to be 8 for Title IX at least.
Yeah.
It was nonpartisan except for the one Justice Alito moment, which I think Alito is a great lawyer and he's a great, whatever, you can have your opinion of him, you can't deny he's a great lawyer from the bench, right? And there was a moment where he says, what about those female athletes who intervened in this case or who don't want to compete against transgender athletes? Are you calling them bigots?
Yeah.
There was that moment. That was the only sort of
That's true. Yeah, good point.
but, yeah.
Who had the question? I think it was Justice Thomas about, he was pinning them down like, you say this is sex discrimination. What is your definition of sex? And ACLU lawyer wouldn't provide one. It does seem weird if you're saying that you're being discriminated against on a certain basis and you're unable to say what that basis means.
But they didn't, as Anastasia said, they're not arguing on the basis of sex, right? They've kind of conceded that classification is legit. But you're right.
No, they're saying that they're saying that it is a sex-based classification to exclude trans people. That is sex-based.
I thought they weren't.
They're also making an argument that trans status itself ought to be a suspect class.
Okay, all right, yeah.
That's their fallback.
Okay, all right.
Yeah. Let's move on. We had Paul Clement back in the courtroom on Monday, trying to reinvigorate the Chevron doctrine. Is that right? Something like that? Oliver, you want to talk about this one?
Well, I'll try. It involves Chevron, and this involves a contract going back to World War II for both crude oil and refining the oil. And the question is where the case should be heard. The Chevron wanted to remove it. The states who are suing it's Louisiana suing on its Coastal Land Protection or Coastal Protection Act, saying that it should be in Louisiana. And there's a lot of back and forth on when the parties made various arguments. It's gone up at least once before, and it again when we discussed the preview, it seems like it's going to come down to what the facts on the ground are. Does what Chevron was doing count for both purposes, the refining and the crude? And if so, it can be removed. It wasn't the most exciting oral argument ever, but as usual, he's so good. And but I don't know. I don't know what's going to happen in this case. This is a tough one.
Yeah, I found it hard to follow at times just because they're just dealing with things that we don't deal with. We'll see. Maybe this will be the new Chevron doctrine, when you can remove. It's better than the old Chevron doctrine. The other case, Gillette versus New Jersey, unless you wanted to say anything about the Chevron case on stage.
No.
Was also jurisdictional, but I found it much more interesting. The New Jersey Transit case. In this case, dealt with whether this governmental, or maybe I'm question begging, whether this entity can be sued outside of New Jersey, because whether it enjoys sovereign immunity, whether it's sufficiently governmental to be considered a governmental agency, in other words. I found this case really interesting. It seems like on the one hand, there is the side that says we look at a bunch of factors, multi-factor tests, how much is the control, yada, yada, yada. And on the other side is a much more straight line, like how was it set up and what choices did the state make at its inception. I think that in the background of all of this is the Biden versus Nebraska case, where the court found standing for, was it MIHOLA? I forget what the acronym was for that Missouri quasi-government agency that allowed Missouri to maintain the standing in that case. They used the multi-factor path for that. And that case even came up in the arguments here, with I think Kagan using it as a, hey, majority, look what you guys did in MOHELA. Now it's going to come back to bite you, or are you going to be hypocrites and go back on the other way? Whereas I think Gorsuch said something to the effect of, well, standing is a different question than sovereign immunity. It doesn't necessarily have to be the same analysis. So they're sort of foreshadowing, if they rule that way, how they would distinguish MOHELA. So pretty interesting legal argument on a high level. I don't know that I really have a dog in this fight. You guys have any other thoughts on this case?
Just there seemed to be some discussion about the distinction between how the federal government treats non-governmental entities or corporations, and how states do it, and whether states can define it for themselves, and I think they can, and then how that would apply. And the other interesting thing I thought was that New Jersey apparently set this entity up, as it has others, in order to get around budgeting laws. So the New Jersey Transit Authority is allowed to borrow money with fewer restrictions than a government agency would. And there was one other. I know what it was in the New Jersey Constitution. Apparently, and I guess this is still in the books, says that the government can have only 20 departments.
Oh yeah, that's right.
And so this entity, the New Jersey Transit Authority, is a sub-agency of the state, whatever, some other department. And so the other side said, well, there you go. It's a sub-entity of a state government department. It's got to be the state. And the response was, well, no, that's just a quirk of the Constitution, which limits us to these number of departments. And so all these statutes creating these entities, they had to be put under an official one of the 20. And so it's just a bizarre, like, just ignore all this stuff. And, I don't know.
Yeah, on the merit, like when the opening oralist advocate got up there and he's like listing all of these things that it does, like, I'm like, wow, how is this not a state agency? It's like he's just going on and on and on. And then the other guy he's like, they made a choice here to not set it up as a government entity, right? So that they could get around things that governments are usually bound by. So we're gonna allow them to take the benefit of a private corporation for certain purposes, but then they can't be sued. And for someone who doesn't like giving the government the benefit of the doubt, that argument seemed to have some force with me. So the other thing I wanted to mention is, in the preview episode, when I hadn't read about the case at all, I was wondering how sort of like the state action doctrine would work into something like this. And this seems like obviously this would be state action. Like, it's not even a question that this entity would be engaged in state action. So the fact that state action can be had and yet they wouldn't be an arm of the state seems odd to me.
But
That's exactly.
Oh, sorry. Go ahead, Anastasia. No,
I was going to say, well, unless if you're going to respond to that, because I was going to agree. So you respond first. If you're going to.
No, okay, all right. But I thought there was a discussion about that in terms of depending on whether the plaintiff sought injunctive relief or damages, and and that under what's the case? Young.
Part of Atlanta.
No,
Ex parte
Young.
Young.
Huh?
Ex parte Young.
Ex parte Young. That so I think it would still apply. The state action doctrine there would apply, but of course that's and the question here really is jurisdictional. So it's not the New Jersey Transit Authority can still be sued, just can't if it's truly a separate entity, it just can't. It has to be, well, the question is whether it's sued in New York, Pennsylvania, or whether it has to be sued in New Jersey.
Yeah.
So the anyway, sorry, Anastasia, go ahead after I.
I mean, I was just gonna say something similar, which I don't want anything, an entity to have sovereign, any entity, including even true government entities, to have immunity. I think it's silly, but it did feel like pretty governmenty to me. But I was going to say, on the other hand, you can really see this cutting both ways. Like if a plaintiff, you wouldn't get damages, but if a plaintiff was suing the same entity for some sort of injunctive relief, you could see them trying to argue that it was governmenty and not private. So yeah, the whole thing is very weird. It just shows how there's probably some gamesmanship that goes into it.
Yeah.
And the government would stop too. The government would be like, no state action, not governmenty, you know?
Last thing I want to talk about, we had some grants today. I haven't had a chance to look over them. I know Oliver has. I'm sure Anastasia has as well. Oliver, what were the grants that we got today?
There are a couple questions involving drug labels, a preemption, whether the Federal Insecticide, Fungicide, and Rodenticide Act preempts label-based failure to warn.
Hold on. I once brought it's a FIFRA. One of my very first cases at PLF was a FIFRA case against the feds.
Was it an equal protection case?
No.
No.
It was a First Amendment. It was a First Amendment case that we challenged. We had a client that sold a bear spray, like a pepper spray for bears, bushwhacker, and the feds issued some guidance that said your advertising for your bear spray uses comparisons, like you're comparing your spray to somebody else's bear spray, and that's inherently misleading. And so under FIFRA, we can regulate it. I'm like, you can't make comparisons in advertising. Like Coke can't compare itself to Pepsi. It was so patently absurd in violation of. So Damien, who isn't here, so I can make fun of him. He was my mentor on that case. I'm like, super excited to litigate this case. He's like, well, let's send the feds a letter beforehand telling them we're going to sue. So we sent them a letter, and they're like, oh no, that's not what we meant. We rescind that, and the case never got off the ground. But I know a thing or two about FIFRA because of that.
Interesting. Then there's one other case on ERISA, and then the other grant today was whether the execution of a geofence warrant violates the Fourth Amendment. And then recently there were two cases that I'm interested in involving penalties, whether penalties under the FCC statutes require a jury trial. And then there's a provision under the SEC securities laws on disgorgement. And the question is whether the government can get disgorgement without showing any investor harm.
So the geofence case, can you say a little bit more about that? Didn't we file an amicus brief in that case?
Yeah, we filed an amicus on behalf of X.
Oh yeah.
Yeah.
Who were our fans? X were all of our fans are watching us right now.
That's right. But I don't know what a geofence warrant is, I have to admit.
I don't either. My sense is that it is like an electronic area that can be fenced off without actual fencing. Someone's Googling it. I can hear the typing.
Yeah.
And then you can search within that area, maybe?
Yeah, I don't know.
Maybe our friends on X can let us. Who wrote the brief for PLF?
Amy.
Okay. Well, maybe we should have her on the next episode of the PLF Supreme Court show.
Yeah.
Or at least when this case goes up to be argued. But so the week started with 6 PLF cases getting denied, and then we get an amicus one getting granted. I'm sure our friends at X are happy for our work in that case, and glad the court did take that one up.
I know what a geofence is now.
Oh, well, lay it on us.
it has to do with cell phones because they have to transmit to the towers, the cell towers, and so a geofence warrant allows the cops to get the identities of the users who are in the vicinity of the towers.
I thought from my Serial, the podcast watching, and fascination with the Adnan Syed case, I thought those are historically really, really inaccurate. Right?
They must
Maybe
be
they
getting better.
were
The tower,
inaccurate.
you go through the Hawaii Tower, even if it's just random.
Is that still
must be.
true, or was it true then and not true now? Or
They got to be
Possible.
getting better. Yeah.
yeah. All right. Well, thanks for letting us know about those cases, Oliver. Any other Supreme Court news you want to relay? We got a
Waiting for that
new.
tariff case
Yeah. When's the next edition of SCOTUS Scoop coming out?
momentarily.
Oh.
Stand by your inboxes, people. I just stole all of Oliver and Joshua's commentary and typed it up, and it's about to go out.
And
I wouldn't do that.
when's your next SCOTUS blog piece coming?
Not this coming Monday, but the following Monday. If you have any suggestions for dissents that I should cover, do let me know.
Okay. Well, you had 3
You're
new ones to
listening.
pick from today, or at least 2.
True.
Talk. You know a little bit something about the double jeopardy clause already. It sounds like.
A little bit.
Okay. Well, thank you, Anastasia. Thank you, Oliver. We'll be back next week. We have arguments starting on Tuesday. Is that right? Okay.
We can't. I'm trying to figure out today, Joshua. I don't even know.
Yeah, there
Right.
are arguments next week. 3 arguments next week. It looks like starting on
Oh,
Tuesday.
it's a big one, the Cook one, right?
What is that
Trump
one? Yeah, Trump v. Cook.
Trump v. Cook,
The
whether
Fed.
Congress can limit the president's removal power over the chairman of the Fed.
Oh, that is a big one.
That
Did
is
we
big.
file in that case?
No.
Okay. All right. Well, until next week, thank you, Anastasia. Thank you, Oliver. We'll be back.